we're partnering with Wes Vine, winemaker at Mandarin Valley Vineyard. Before I go on to say that, I would like to thank Mark Coffey. We're at the wine bank yet again, the most beautiful place, I think, in Bendigo to come and enjoy a glass of wine. Mark, the reason I chose Mark, to come back to Mark, and I was talking with Wes before we went live, is that Mark is a wonderful supporter of local wineries around the region. And he supports them, encourages them, displays them. And it's a beautiful venue. So I thought we're better to have our little session today than here. So here is Wes Vine, Andrew Wine. I was asked a couple of questions. So talk to us a little bit about your winery and how you came to have your winery.
Well, it started we shifted to Bendigo in 1975, and we had previously purchased land at Mandarin back in 1973, I think it was, while we lived in Melbourne. And when we got here, we had something like 4 acres, and we were sort of thinking about what we could do with it. And I was half interested in having a go at the winemaking process, so we decided to plant grapevines. So what started a hobby has now got out of control, and it's developed into a significant business. So it was, it just started with an interest. My training, university training, is sort of in the field that allows me to understand the winemaking science. Yeah. So I could understand the winemaking chemistry and so on, and the winemaking process. So it was just a matter of developing the palate we've been working hard at that, developing the palate so that you can recognise wine faults and you can deal with them before they get to the point where you'll be offended by them when they get to the bottle. So it's been an interesting development, and over that time we've become contract winemakers as well. We make wine, I think it's for 22 other entities, as well as making wine for themselves.
So what was your work before you became a winemaker?
I was a school teacher, and I was the principal of Eagle Secondary College for 12 and a half years. So
that's quite a career change.
So I took to the alcohol. No, that's not true. No, I had a great time there. It was really a rewarding part of my life, and I think very fondly of it. Darwin. Yes.
So talk to us a little bit what sorts of wines you make, and then we'll get on to a signature wine today, which we're all absolutely adoring here.
Well, when we started, of course, Bendigo being Bendigo, the main variety, I suppose, that it's recognised for is Shiraz. So we certainly started making Shiraz, and, the typical French varieties like Shiraz and Cabernet, some Merlot, but then into the white wines, we were making Chardonnay and Riesling. So over time, that's evolved. I mean, what we've added to the range is, for example, the GSM, which is Grenache, Shiraz, Monoscro.
What do you like the GSM?
Three varieties. I think the two wines that I probably like most, and I'll comment on this one in a moment, like most in our range of blends, and they are the GSM, which I've just described, and the other one is the old wine, which is my favourite. And it's a Cabernet, Shiraz, and Malbec. So it's a blend again. And I think blends are very, very interesting wines. If you take a Shiraz on its own, yes, we will like it. But if you think about it, Shiraz doesn't have a whole lot of aroma, really. No. So it's a bit dumb in my view. Interesting palate. It's got some very nice notes on the palate, particularly from a region like this where you go right down the south of the region, you get a lot of pepper. Come up our way and you're into spice, and you see so many different representations of Shiraz. But I sort of like looking at getting length into the palate, getting breadth, and the fact that I suppose the aftertaste lingers. And one thing I feel very strongly about with wine is the nose. I think if a consumer dislikes the smell of a wine, you're not going to sell it very easily.
Just like the smell.
Well, usually if the smell is good, it'll be a good wine. Often the smell often telegraphs faults that may be occurring in the wine, and you definitely see that on the palate. But if if a person picks up a glass of wine and they smell it and they give it, they're in a good frame of mind before they go to drink it. So the first impression is very, very important. And of course, the colour of the wine too. And I can go on a bit about this.
Talk about this, because I will say, and I don't know what rosé I had before I tasted Wes's rosé, but when I got here, I do love a good rosé, and I had a glass of rosé, and then I had this, and I said, oh God, why didn't I start with this?
Well, I think the thing about rosé is it's really a red wine being made in the way you make a white wine. So what you're trying to do is pick the grapes at a time when they've got very good acid, where you don't have a really high sugar level. I would say low to moderate, and you're looking for crispness and a palate that's really quite smooth, even though you've got quite a bit of acidity on the front of the palate. And where I think the rosés go wrong is a lot of them have just an edge of tannin about them. They're just slightly tannic, or they've got what we call a phenolic character. It's a skin character in the wine, which I personally I really don't like. And in making rosé, I'm sort of about trying to avoid some of those things that I've just talked about.
Can I say something? I went off rosé for years, like 20 years, because a lot of the rosés have things like olive water. Yeah. And the dry ones are just divine.
What happened then was, of course,
my lovely husband's got me another
we started to take a whole lot more notice of the French styles of rosé, and they were different. They're not high in alcohol at all. They're probably running at about 12, early 12s, and that's a really good place to be. If you look at your sparkling wines out of Champagne, you know, they'll be somewhere between 12 and 12.5, a little bit higher, but not to the point where the alcohol drives the wine. And because you can't do that in wine like this, it's very light. So that brings us to the grape variety. This is Grenache, and the grape, in my mind, Grenache is the Rolls Royce of varieties for rosé. It's to do with the nose. It's got that rosewater character, and we can get that, but it's almost like Turkish delight on the nose, and that carries through. And I think on the palate, it's just got a nice, fresh, fruity fruit of the Grenache is rather interesting because picked early, it's got quite a tubey, the tubes, the lollies, it's got quite a bit of that sort of character. So we were in a position where we tried to pick some of it to make a wine like this, and then some more of it. We've got to let ripen to make the GSM. The GSM has become one of our sort of most sought after wines, actually. So we've only done this once before, 2016. This is 2018. So we've had a bit of difficulty along the road because we haven't had enough Grenache to do both jobs.
You mentioned before that you export, well, pre-COVID you export a lot to China. Yes. Is this one of the wines you export?
No, Shiraz. Yeah, China is more than interested in Shiraz.
People joining us, which is lovely.
So, the Shiraz, we've managed to sell what we were intending to export this year locally. The COVID probably has helped us in many respects. So we won't often hear too many people say that, but it's obviously it's been devastating. But for a few of us, we just happen to be in the right place at the right time.
I think we've got a few business people here today where COVID has, I think, I won't name names, doubled their business.
Yeah. Significant.
And we have an accountant here that's, I'm sure, has tripled his business. So it's helped a lot of people and it has really hurt a lot of people.
Yeah.
But look, I might get on to the legal side. Wes will join us again at the end and give you all guys a special offer on this lovely wine. And I'm not exaggerating to say this is as good or better than I've ever had. So.
Yes, I just could you know,
yes.
we don't do the whole process. We make the base wine. We don't have the specialised gear to do the sparkling side of it because it's quite a complex. So we send it down to Kilchurn Wines down in Romsey, and they do that part for us. And part of the process is you send your wine down, they bottle it all and put the second yeast in and some sugar for it to ferment the second time to get the bubbles. And then it goes through a process where it's shaken and then ends up upside down. The bottle is in reverse. Then it goes down a line. The neck of the bottle's frozen and blows out a slug of what was the yeast and any sediments. And then they top it up with liqueur. And the liqueur is made up of some of the same wine, but it's got a certain amount of sugar in that, and that's legal. So we go down to taste it, and it's. I've never been quite as stressed, I'd have to say, as when we went down to pull the cork out or take the. It's actually got a crown seal on it. That's to take the crown seal off and have a taste of it. And what I was really nervous about was the colour, because I was really after just exactly this. And when it went down, it was a bit more red than this. But because they used bentonite in the process of getting the yeast to settle out, then it stripped some of the colour out. So it's turned out exactly the way I wanted it to.
Well, it tastes magnificent.
Yeah.
So you're well done.
Yeah.
Give me a toast before you go. Wes will join us at the end to talk about our special offer for you guys. Let's get on to employment law, for those who are interested. I don't think I need to introduce myself anymore to people, but my name is Rosa and I'm here to help. But I'd actually like to introduce a new employee I have. I always do this to her. Come on, man. I'll stand. Where do I stand so you're on the screen? There you go, you're on. This is the wonderful Anne Conway who has joined me. How long has it been now? A month? 6 weeks?
Yeah, about 6 weeks, I think.
Anne is an HR guru. She used to be the HR director at Hazeldean, so she used to manage over 1,000 employees out there. And I was lucky enough to snaffle her, and she's working with me now. So the business is going to branch out to do HR consulting work as well as the legal side, which means that, you can. I think it's good to have an HR person in your organisation rather than a lawyer, because people don't really like lawyers very much. So Anne will do a lot of the day-to-day, because you can do enterprise agreements, investigations. We're doing a lot of policies. I think you're Todd, aren't you? Todd's here, and he's just bought a whole suite of policies, and we'll offer this to you as well, Michael, and Anne's going to go in and train his staff and on, or I don't know if she can do it yet, but we've got to, you can't just launch policies. It's good to do a training session on the policies so people understand their rights, their obligations. And it's not just here's a document, read it, sign it. So Anne has metamorphosized my life, because I was under a bit of pressure and Anne's come along and taken a lot of pressure off me, and I'm delighted to have her on board.
Two-way street, Rosa.
So welcome.
Right, thanks, Rosa.
So I'll talk a little bit more about, you've all seen this. I've been in this space all my life, really all my working life, and I've only been a lawyer for about 12 years. And my joke last week, because I've had a bit of funny interactions with a few lawyers in town, is that I didn't really know that I didn't like lawyers until I became one. I had to work with them. And then I realised I didn't like them at all. But I'm a nice lawyer. As people here who know me know, I'm a nice lawyer, and I'll always look after my clients. And I had someone who wanted to work with me recently, and for a lot of reasons I couldn't work with her. She goes, I just want you because I know that you will fight for me until your dying breath. And I do, because I love it. I'm very passionate about it and I love it. I'm having trouble with it. So the services I offer, well, now I should change this slide because it's that we offer. We can certainly support you through every stage of employment, from hiring people to firing people to performance managing them to investigating them to doing anything. Anything you want to do with your staff, we can help you do it. I've got a lovely quote here from Michael. Michael Keane is here. And I've got a lovely quote. I think my favourite quote is this one on the right. I don't know, it's on Zoom, but this was a guy who just rang me out of the blue, and he'd been really shafted at his work. He was sort of, I think he was suspended. They were going to do an investigation against him. It was just all this stuff, and it all just seemed to come out of nowhere. And I just loved what he said, that he'd still be battling for his basic rights if he hadn't come to me, and that we'd recommend, he left, but I got him a good exit package to go because they had stuffed up, the employer, and so they knew they'd stuffed up. So I pointed out in quite clear terms exactly how they'd stuffed up, and they were quite happy to help him leave. There's been some interesting stuff going on. I'm going to talk about a case that wouldn't have got a lot of publicity, but Anne and I were laughing about it today, saying, how can this happen these days in the workplace? But it does happen, so I'll talk about that. That's the first one. I'm going to remind people about the BHP case. I talked about that a few weeks ago or last month, but I think it's important because we're now getting people back to work, so we need to do that carefully. On that point, please check out our website. There's a free resource that the lovely Anne has designed about how to get your people back to work in an appropriate way. And it's just so overwhelming, all the websites out there about COVID at the moment. I can't get my head across them. But Anne spent some dedicated time for all the resources together in one booklet, all of the links to all of the resources so that you can just get one space where you can get everything you need to know. I think this is an interesting question, terminating a casual. I've had a lot of, not this wave so much, but the first wave, a lot of people who were on JobKeeper and at home and wouldn't come to work. It was really good. What a good gig, you know. You got a 4-hour-a-week casual job and suddenly you're earning $750 a week and you're sitting at home with your feet up. So I'll talk about that a little bit. I want to talk about this. This is probably a bit pointy-end legal for this sort of seminar, but I think it's a really interesting case, a few cases about the Superannuation Guarantee Act and how they deem certain workers to be employees and the consequences of that. And I want to talk about something that's upset me today is appointment of two, because I'm left-wing, people who don't know, though I represent employers and employees, my natural inclination is sort of more left. Julia Gillard was my idol. Two very conservative appointments to the High Court, which affects every one of us. This, I don't know if you can see that with that. Can I hide that thing up the top there? Anyway, this is a case where, let me just see, it was Sydney Water and Vitality Works Australia, who was a consulting company who they'd obviously engaged to do some marketing for. What they did was they took a photo of an employee and without her consent, she consented to the photo being taken for marketing purposes, but she certainly didn't consent to what they then did with that photo. They put it on a poster, like obviously it must have been an attractive young woman, and said, "Feel great, lubricate." Michael's look at his face. I mean, who would do that? Like, it's just, okay, and I said, look, are we living in the 80s, you know? It's just Sydney Water. So they failed to, it was in New South Wales, they failed to convince the equivalent of VCAT that they could only breach the sexual harassment legislation if the conduct was intended to be sexual. The tribunal said that innuendo was enough to breach that legislation because it was pretty clear that it was sexualised behaviour. So while she let them take the photo to promote Sydney Water OH&S campaign, she said when she saw it in the display beneath that, you know, heading, she said she nearly collapsed. Like, who wouldn't? So she said her humiliation was further exacerbated when she started getting texts from blokes at work. Said, "Oh God, where's that from? Are you missing me?" I mean, really, you just want to die. As a woman, you would want to die. So regardless of Sydney Water's purpose and intention in displaying the poster, the panel at the tribunal said his conduct was of a sexual nature because the double entendre intrinsic in the poster viewed objectively as apparent that it's sexualised. The lubricant is so closely associated with sexual activity that it was actually sexualised. In other words, they said Sydney Water's intentions and objectives weren't determinative of the question of whether its conduct constituted conduct of a sexual nature. So their intention was of no consequence. The fact that they did that was enough. So the conduct was sexual harassment. They said it was discrimination as well because they would never do that with MAG. So MAG would never have that poster put up. So they said it was sexual harassment and conduct. I'm going to talk a little bit about this case. I talked about it in my last rewind, but I think it's really important. BHP, those who saw my last session, they had what's the name of the agency? I've got it there. A recruitment agency had a lot of staff on their side in one of the mines. And what they wanted to do was there's vulnerable workers under the COVID regime, people who are older, people, Aboriginals over a certain age as well, people with chronic health issues. So the nationwide program to protect these workers was part of the health risk group to stay home. So they wanted these workers to stay at home. So the group included Indigenous workers in their 50s and non-Indigenous workers over 65. They were pretty good. They gave, I think it was $3 million to pay these workers while they were at home, because a lot of the workers through the recruitment agency were casuals, so they didn't get any other pay. People who were employed directly were paid by BHP. But what happened was the money ran out. Chandler McLeod, everything. The money ran out. So these casual workers were unpaid for 3 months. So the union accused BHP and Chandler McLeod of breaching discrimination provisions of the Fair Work Act because workers suffered loss because of their race, their age and their physical disability. And it said, even though their intentions were to protect these workers, they stuffed it up basically by basically allowing these discriminatory elements to be the deciding factor as to who got paid and who didn't get paid. I think in looking at it, there was a hearing, or there was the initial hearing on the 9th of October, and I haven't had a chance to update it, but I might update it and put it on the website. I think if they had have paid them for the whole time, they would have been okay. The fact that they lost 3 months' pay because of their race and their age made it discriminatory conduct. So be careful. Ring Anne if you're thinking of doing anything.
And I think the other thing was if there wasn't ongoing communication with workers as well.
Yeah. High and dry. Because you've only selected people because of their race.
What if you go on the other flip side of the coin and they're employed because of their race?
You can ask me difficult questions later, Jared. Well, there's provisions for example, in the Equal Opportunity Act that allows for positive discrimination, particularly around women. So you're actually allowed to positively discriminate.
But the BHP was trying to protect them.
That's right.
Because they're obviously an at-risk
That's right.
person.
But they mucked it up. Let's talk about what do you do if you've got a casual on JobKeeper who refuses to attend work. So generally casual employees have the right, as we know, true casual, not the casuals I hate where you have them every week for the same hours, but a true casual is generally allowed to accept or refuse whatever shifts are offered to him or her. And at the moment, because everything has happened so quickly, even with the changes to the Fair Work Act, there's no clear measures in place to deal with this particular issue. That the Fair Work Act and the Commission haven't considered that. So, because there's nothing overtly in the legislation, the usual terms and conditions that apply to a casual would continue to apply. So, where a casual just doesn't tell you they can't work, if you've got sort of like, if you can't work, you've got to give us 24 hours notice or whatever, and they don't do that, or they refuse without a valid reason, then an employer could consider disciplinary action. But you've got to be careful that it's really complicated in terms of don't take disciplinary action because of a discriminatory reason. So I've got a case at the moment, and I actually haven't had a chance to talk to you about this, Anne, because it ships the night all the time, where a worker was directed by his employer to attend work because the restrictions had lifted, and he didn't want to attend work. The real reason, or there's two reasons. One was his wife was sick and he wanted to care for her. She had bad respiratory problems. But the second was he had genuine concerns about health and safety risks in the workplace. Concerns and expressing concerns about health and safety is a workplace right. So the fact that they've now stood him down on full pay, but again, it was really confusing. They stood him down on full pay and said, you're not allowed to have any contact with clients. But they didn't stand him down and said, this is disciplinary action. They just stood him down. And then they said, actually, can you do this work for us? So it was incredibly confusing. But the point I'm trying to make is be careful if you do something with a casual that you don't do it for a reason that can be later, thrown in your face. And you call me and say, Rosa, I've done a terrible thing and I have to come in with my magic, lawyer dust and sort of try and get you out of trouble. If you're ever going to dismiss someone, please just get legal advice first. $1,000 spent up front might save you 10 down the track. So. this is something that upsets me quite a bit because, as I said, I'm left-wing, and unfortunately the Morrison government has put a very conservative stamp on the High Court today. He's appointed two very, very conservative justices, Simon Stewart and Jackie Gleeson. Jackie Gleeson is the daughter of Murray Gleeson, who was appointed by the Abbott government. They're both strict black-letter lawyers, and what that means is they will just interpret any legislation in the narrowest possible way, not giving any room for latitude in any way. The government and the supporters think it's great. They're so delighted because it will reduce what they call judicial activism. That's my favourite judge, Kirby, was criticised through his whole career for being an activist. What that means is he did things like sort of read outside the black letter of the law. He'd try and read widely and interpret it, social context and all sorts of things. They hated him. So this is really a win for conservatism. And the reason I hate that is because it's a way that governments of any political persuasion can keep their views alive well after they've left political office. So if you put a really conservative judge in there, justice in there, then who has your views, then your views survive for decades. So I'm a bit upset with that. We saw the same thing happen in the US in the last month with the passing of, Ruth Bader Ginsburg. She was a furious opponent of Trump. Her dying wish that she could live long enough to make sure he was out of government. Unfortunately, she didn't. And she was just fanatical about gender and women's rights and all of it. And, I think the whole female world, I don't know if you saw it on Facebook, just mourned with her passing. And she was appointed by a Democrat, of course. So what's happened? My husband told me today, because he gets up every morning and scours the newspaper, that Amy Conway Barrett was appointed just today as her replacement. And you only have got to read the stuff around it. Republicans are thrilled by her appointment. And she's going to sit on the most powerful court for decades to come. This is the first time we've had a woman who's unashamedly pro-life and embraces her faith. So she's a conservative, religious, right-wing appointment. Trump is desperate to overturn Roe versus Wade. Have I put that there? Let me see the next. Roe versus Wade is the original decision that legalised abortion in America. He's desperate to overturn it. He said if it was his last wish in office, he would overturn Roe v. Wade. She refuses to answer any questions about Roe v. Wade. So it's scary times ahead. She paid leave, affordable childcare, equal pay, voting rights, racial justice, LGBT, everything that has come to the fore under Obama is going to be out the window under that new regime. Because ultimately what happens is decisions go up the chain, as I've talked about in these presentations. They get to the High Court in Australia or the Supreme Court in America and the judge decides. So if their orientation is that way, then they're just going to say no. So it's almost tear worth that, all of that. I think I didn't put this here, but again, one of the comments made by Trump was that, or any supporters, was that they've got a woman, like a woman who personifies womanhood on the Supreme Court, and that their definition of her personifying womanhood was she had 7 children. That's the only way that women are defined under a Republican sort of stance. Anyway, I'll move on from my political views to some legislation. I want to talk about the Superannuation Guarantee Act. Do you do much in this space, Michael? A little bit. I think this is really interesting because there's been some really interesting decisions in recent times. As some of you may know, an employee is defined differently under different legislation. So an employer can be an employee under the Fair Work Act in a certain way, but then differently defined under health and safety, and certainly under the Superannuation Guarantee Act. And that's where a number of employers have become quite unstuck in recent times. So this Act there's provisions in there that deems certain workers to be employees, even if they're independent contractors or something quite different. So you may recall my discussions in the Janset case where the truck drivers were engaged as independent contractors, but deemed, this was the scary bit, I haven't seen any appeals yet, after 40 years to be employees. What that meant was the employer, at first instance, was liable for 40 years of annual leave, 40 years of everything, public holidays, superannuation, everything. I think it's on appeal. So. But the first case was on-call interpreters, and I think that was a transcription company. The court said that the deeming provision will apply when an independent contractor provides personal services in an employment-like setting which was not of a domestic or private nature. So that sort of means that if the work could have been done, according to the court, an employment-like setting arises when in all the circumstances the labour could have been done by an employee. Okay, so it was really clear-cut. I'm not going to go into the dental corporation. This was a recent one. This is 2020. They didn't follow the same test that was followed in on-call, but they came to the same view. So the Superannuation Guarantee Act has had, dramatic effects on this. I've actually got a case on foot at the moment in exactly the same circumstances where I've got this lovely fellow who's a independent contractor truck driver employed by a very, very big Australian company. He's employed for 12 years, I think, and he was dismissed under very dubious circumstances. In fact, I'll tell you the circumstances. I find it astounding. It was like he's a truck driver, right? So he's out in Swan Hill on a 42-degree day, comes back into the tea room. He's got like a little bit of water in his water bottle, and his friend, who he visited in hospital when he had a heart attack, was sitting there, and he tipped it on his back with his shirt. He was dismissed for serious misconduct. He was mucked around by some lawyers, by his union, by a whole lot of people. But I'm really keen to run a case on this. So I briefed a barrister and we're ready to go because he's a single dad with 2 kids with disabilities and that's how he's treated. So I'll always fight on the side of right, whether it's employer or employee. Oh, this was the depths. I'm not going to go through it because it's a bit... Oh. I want to talk a little bit about underpayments. Those who've come to my seminars in the past, I know Michael has, and my early seminars I used to run at Matchwork before COVID. Underpayments, again, is such an area of, I don't know why you would underpay staff. This is not worth it. So this case, it's the, I've got the case on the next page, but the Fair Work Ombudsman is quite aggressive in its determination to pursue people who underpay. And it's got, as I've said previously, it's got enormous powers to enter your premises, to demand your payroll records, to demand everything. So they have fined this cafe in Northcote $232,000 in penalties. And I think there's like $180,000 staff members. Yeah, $180,000 in underpayment. The thing I think that was really determinative was the court found that the company, they knew they weren't meeting their obligations. They knew they were underpaying. They just continued to do it in breach of the legislation. So they're paying flat rates of $18 to $25 an hour. Don't get me wrong, you can do flat rates. You can do what is called set-off clauses in your contract. So if the minimum award is, say, $22 and you pay $30 and you say this is in compensation for any overtime or whatever, you've got to keep records. It's not a straightforward. You've got to keep records to make sure that they're better off. They're not losing out. You can do flat rates, but they didn't do this. They just paid a flat rate, Saturdays, Sundays, whatever, those rates. They got pinged. They also found that they deliberately contravened the adverse action law. So you recall that adverse action is where you go and complain, I'm being underpaid, and suddenly you're getting more shifts at work. It's where you suffer detriment because you're trying to claim your workplace right. Because they didn't offer any further shifts to an employee who challenged the rates. So employers are on notice. You must pay all your workers according to the minimum pay rates or risk significant financial penalties. And as I've said, they're quite ruthless with it in a positive way. The case is the Barry Cafe case. If people want the full reference, I'll give it to you. As always, my recommendation is when you're in doubt, get legal advice. Get it early and get it often because a little bit of money spent up front might save you an awful lot of money down the track. And not only money, it's reputational risk. That cafe's name is now on every website everywhere about how they underpay for their staff. And I think that's me. We might get Does anyone have any questions? Is there any questions in the chat? I never really get to questions in the chat. Anyway, anyone got any questions? Other than you, Jared?
No. It's not to do with anything you specifically mentioned this afternoon, but certainly in regards to the performer contracts that you supply to your clients, and we avail ourselves, as you know, of that service. And I'm thinking of clients that have employees that work with clients, and the possibility of those employees deciding to leave and
take their business, steal their clients.
Yeah. I'm just wondering how your performer employment contract deals with that situation.
Well, we've got very, very robust restraint of trade clauses in there. So restraint of trade it's a really complicated area because the courts are very loath to stop someone earning a living. But then there's also, so that then is competes with an employer's right or a business's right to protect its legitimate business interests. So it's a real challenge. But we certainly have got the restraint of trade clauses in there, the cascading ones where 3 months, 6 months, 12 months, 5 years, whatever. You can't do this, you can't do that. You can't approach clients, you can't entice clients, you can't do all this sort of stuff.
Is it more? This is just a
it's not.
But I've heard over the years that doesn't really.
It's difficult. It is difficult. I've got a matter on foot at the moment. The matter I've got on foot at the moment is interesting because it's a sales agreement. So this company bought another company, and then that director of the first company started to work for the second company. So they had restraint of trade clauses in the sales agreement and restraint of trade clauses in the employment agreement. Certainly, the sales agreement ones are easier to uphold because the court views two commercial entities as being equal in power and able to enter into a contract on that basis, whereas the court will always think the employee has a much lower position. So there have been ones that have been upheld, though, a lot of them. I can talk about that another time if you want. I can do a session on restraint of trade clauses because, interestingly enough, I've had a lot of cases in the last couple of months, and one that again is going to go to the federal court in the next month or two. It's interesting.
Case of deep rust. That's a problem.
Which one was it?
You did a case for us.
Oh, yes, early on. That exact problem.
That exact problem, and we were advised not to chase it because it turns out it's created its own dramas, its own life. But the point is, it's interesting, and I don't understand it all. That's why I'm going to talk about you. But I find it interesting that it's very heavily weighted in the. Why would you even include these clauses in there?
Because no, because they do have some weight. I'll talk about some cases that have won. Employees have won, and it is interesting. But again, like I said, the courts are really hesitant to say you can't earn a living. Do you know what I mean? So they really have to find something to enforce them. Something.
Interesting thing is that particular individual went into got the benefits of what he got because of, and that meant that he couldn't restrain. That meant he couldn't take our intellectual property into his own thing with it. And then he was kind of cognizant at that point. And so the court doesn't take that into account?
Yes, that's a separate issue. The confidential information in IP is heavily protected. Yeah. So that's not about you earning a living. That's about you stealing something from your employer. So that you can litigate pretty easily.
Yeah.
So we have both in the contracts.
Yeah. Very simple, isn't it?
Look, I think law is really interesting because I suppose that's why it always appealed to me. Like I was good at maths in school, but I thought if everyone gets the same answer, how boring is that? You just add it up. 1 1 is 2. Yep, we all know that. So I actually like the fact that there is no right answer. And, someone can make a decision, then it can get challenged and get overturned, and someone else has got a review on it. I find, well, as you can tell, I find it fascinating and interesting and costly. My prices are very reasonable, Darren.
No, I'm not saying. I didn't mean a simple job of trying to protect your business, your people in it.
Yeah.
And it's not your cost, it's the ongoing cost. It's like
And I think, like I always say, get the right advice up front. Todd's done a great job because he's starting his business. So he's come to us and said, give me the contracts, give me the policies. I want to make sure from the onset I've got everything in place to protect myself and my business. And if you, sorry? Yeah. But I think, and I know it's hard because I'm a small business, and you don't want to spend money that you haven't really got yet because you're just starting out. But
times are changing. Like the trust in people is kind of gone. Like when when I first started, you can't take them at their word and trust them.
Yeah.
Whereas you can't now. That's like right. I understand exactly right. You can't trust them.
Well, I've talked about it in my newsletter. I don't know if anyone's read my newsletter yet, but I talked about a case that I was hoping to deal with in Bendigo that I was ultimately excluded from dealing with for complicated, stupid reasons. But the employer, it's another law firm in Bendigo, it's just ridiculous, said to their employee, Jane, we're thinking of making you redundant, grabbed her laptop off her in front of her. She's a lawyer of 12 years standing, grabbed her laptop off her, marched her out of the premises in front of the junior lawyers and all the admin staff and sort of dumped her on the street. So I think it cuts both ways. Like in my newsletter, I've seen some atrocious behaviour from employees and employers. I've got an employee at the moment. I'm representing an employer, and he's been a client of mine for 12 years because, as you know, I had a practice here before I had the terrible twins, and I had to close it after I had the terrible twins because I was sleep deprived, and I knew I wasn't giving good legal advice. I'd better quit. And he's legitimately restructuring his business. He's going from a model of employee to an outsourced model where he just gets contractors in to do the work as he needs it. He's in a building sort of, And I helped him design a restructuring thing, helped him design something to select his employees, how to do it, how to assess people. And this employee is just furious that he was the one who was selected to be made redundant. Well, suck it up. It happens. Get on with your life. But no, he's taken us on to the highest level. So, again, bad behaviour. Just get on with your life. It was genuine. It was genuine redundancy. Anyway, the final thing I'll say is I'm having a lot of fun because I'm not usually a litigator. Well, I'm not a litigator, but I've been thrown into the litigation sort of realm in recent times, and I'll tell you something about, and the commissioners can be judges can be worse. Judges can be worse. I've actually had a judge screw up a bit of paper and throw it at me across the bench and tell me that I should know better. That sort of put me off for 10 years. So I'm starting now, I'm going back into it. But I have this Commissioner Deputy President Masson, I'll name him because he hasn't done anything wrong, and I went to a conciliation with him, and I kept forgetting that he was a Deputy President, and I kept calling him Commissioner. And at one point he stopped and said, my title is Deputy President, Ms. Racco. So he didn't really like me very much. So last week I came up against him again in a mention. I hadn't done a mention of the Fair Work Commission before. I've done some directions at Federal Circuit Court, but I hadn't done, and I wasn't really sure. So I rang his this is the same matter about the outsourcing, right? So my client, the employer, doesn't want to have anything to do with his employee anymore. So he's not going to the conciliation. He's not, he doesn't want to attend. He just wants to hand it over to me and say, just sort it for me, Rosa. So he rang me and said, do I need to come to this mention? And I said, no, I'm sure it's fine. Then I rang the associate and just asked her a few procedural questions. But I didn't say to her that the client wasn't coming, because it didn't occur to me that was an issue. But under the Fair Work Act, because I'm a lawyer, I've got to seek permission to be there. I can't just, because it's really designed for unrepresented litigants. Like it's really about people can just go and get their rights. And so I prepared and so I stood up and I said, I seek permission to appear. And he must have remembered me, I think. Looked at his patrician nose and said, Ms. Racco, you seem to be under the misapprehension that I'm going to give you permission to appear today, otherwise your client will be here. Because it hadn't occurred to me that if he didn't give me permission to appear, he was going to appear. So I spent the next 30 minutes, and Anne was sitting at the desk laughing. I must have called him Deputy President 35 times in 30 minutes. Yes, Deputy President. Thank you, Deputy President. I sincerely apologise, Deputy President. And in the end, we're friends. But it's a fun life, really, doing all this litigation.
Another organisation I was working for at the time, and General, the CEO was stealing money. So, and he brought a lawyer along to his mention.
Yes. And you can
We, I
check
didn't
it
know
out.
that. We had our legal situation, and they'd set it all up. They'd obviously done it all, so I didn't feel it at the time, but he's why you got to check them.
Well, his point was that it was a really valid point. If he didn't give me permission to appear, who the hell was going to appear?
Yeah.
So it's a really interesting world, and I'm thoroughly enjoying it, which is good for my clients because I'm passionate about what I do. I love what I do, and so does Anne. Anne is so passionate about what we do. It's just such a fun. We've got such a fun, happy team where we work that it's just a joy to go work with them. Really? I try and manage that with people because I forget that this is what I do every day. But usually when people come to me, it's at times of high anxiety and stress. So we try and, bear that in mind. I might sign off because usually I go for half an hour and I've nearly gone for an hour. But Wes is going to come up and talk more about his wine and maybe give you a special offer.
Maybe someone might like to ask a question.
It's got more than 4 acres now.
Yes, we see because we make wine for, as I said, 22 other entities, we do a bit of trading.
Sorry to maneuver you. There you go.
We do a bit of trading with a great situation. As well as that, we've got 2 or 3 other vineyards that we access. So we would process about most years 60 to 70 tonne, which if we divide that by 2, that's about how many acres.
So 30 acres. Anything else? Any other questions?
Well,
Do you like a rosé, Michael?
This one,
Yeah. It's really nice, isn't it?
we as I said, we only got it a couple of days ago. We had family around last night and gave it a bit of a try. And the thing that we found, it was as it warmed up, often with sparkling wines, as they warm up, they become accurate. They get some flavours about it that was not particularly nice. That's why we freeze the guts out of it before they're served. But in this case, I think I prefer it when the temperature is probably up around about 10 degrees. It's got the aromatics are much more forward, and which lifts the palate too, I think. But bear in mind that this wine was only, the cork went in about 3 days ago or 4 days ago, so it hasn't really had much time to settle down in the bottle. So when you pour it at the moment, a fair bit of gas evolves, which will settle down a bit as been in the bottle for 6 months or so. Price, it's $28 normally. The wine bank will be stocking it, I think.
I think 25% off if you buy a dozen.
Yeah, not with that.
Not with that, okay.
So we'll do a special on it, it'll be $25. So it's in 6 packs, so what's that? It's $150, I think.
How much?
very lovely.
Very lovely.
It's not cold.
We're going to toast.
We're going to have a toast. I think that's it's all part of the show.
Celebrations already.
Oh, you didn't
He did well too. He did well too.
I don't want to shout out for rosé in my. I saw Gary shake.
It's certainly got some bubbles.
Toast. Thank you for coming along.
Pleasure. And I don't know whether you know where we're located. We're just out off Tannery Lane. It's about 10 minutes out of Bendigo. If you want to order some, I can't supply through here yet because they haven't got it. So probably won't be till next week sometime. So if you want to contact us, you're all on Facebook.
It's on the screen there behind you.
I've got your details there.
If you're on Facebook, the easiest way to do it is look us up on Facebook and there's a sponsored post up. Just press the button. I'll get a message.
Oh, I've got a question in chat. Oh, look at that. Hello, Anne. Okay, we'll sign off. Thank you, everyone. We'll put this out on Facebook as a live recording. So stop share, end meeting. How do I do this? See you, everybody. Oh, end meeting.